under the topic law of contract, we have already looked at the definition and the formation as well as the essentials of a valid contract. Then offer and acceptance, and also advertisements, and valid, void, and voidable contracts. Today we are moving on to the important terms used in the law of contract. In this lesson, we are going to talk about express terms, implied terms, conditions, exemption clauses, unsigned documents, and also the signed documents. And at the end of the lesson, I'm going to list for you the frequently asked exam questions relating to this lesson. Now, first of all, the express terms. Express terms are the terms of the agreement which are expressly agreed between the parties in a contract. They will be written down in a contract between the parties, but where the contract is agreed verbally, there will be the terms which are discussed and agreed between the parties. Those are express terms. These terms are laid down by the parties themselves. The types of express terms we meet every day include charges, delivery, returns and warranties, as well as payment negotiations. But we also have express clauses entitling cancellation of a contract, and these include the forfeiture clause. This clause is found in lease contracts. It is a clause which entitles the landlord to cancel the lease and have tenant ejected if he breached certain terms like payment of rent. Then we also have the foreclosure clause. It is found in mortgage contracts. It is a clause entitling the mortgagee to call up the bond where the mortgager is in default, usually failing to pay interest on due date. Then the last one is lex commissoria. It is found in sale contracts, especially the credit sales and installments. It is a clause that allows the seller to cancel contract on breach of terms of contract, usually non-payment of the purchase price. Next, we have implied terms. Implied terms are terms implied into the contract by the courts. They are not expressly set out in the contract but are taken to be as effective as if they were and as if they had been included from day one of the contract. These are read into the contract by the court on the basis of the nature of the contract. For example, vicarious liability in the law of employment. Then we also have implied warranties against eviction and latent defects in law of purchase and sale. Now let us look at the types of implied terms we have. The first one is that which is implied by law. These are rules of common law relating to a particular type of contract that are automatically implied in the contract. These implied laws define the rights and duties of parties in various circumstances. For example, implied guarantee against defect in law of purchase and sale. Then we also have those that are implied by trade usage. Those who trade in a particular market tend to develop terms which will be implied in that specific trade area. Those are the ones we are saying they are implied by trade usage. Then the third one is those that are tacit terms or implied by facts or circumstances. This is derived from the common intention of the parties, but not expressly highlighted in the contract. They are the terms that are derived from the common intention of the parties, but they are not exactly expressly highlighted in the contract. For example, if I buy cameras online and ask the camera company to deliver the cameras in Zimbabwe from China, it is implied that the camera company will act as my agent in negotiating the delivery of that camera into Zimbabwe, that is my country. Number 4, we have imposed terms. These are terms made to another party in a contract on a take it or leave it basis. These terms are found on tickets, notices, and programs. These imposed terms apply when offeree is aware of the terms before contracting. Then lastly, we have time terms. These are terms as to time of performance. This is implied when contract outlines the exact time when contract should be performed. Those are the types of implied terms. Now, let us move on. We want to look at conditions we find in contracts. Conditions are a special type of terms which makes the operation of a contract dependent upon the happening or non-happening of a future uncertain event. This provision in a contract states that on the occurrence of some uncertain future event, an obligation shall either come into effect or be discharged. Those are the conditions we are talking about. So, we have different types of conditions that are given in contracts. For instance, suspensive condition or condition precedent. Then secondly, resolutive conditions or dissolving conditions. Then we have casual conditions, potestative conditions, and mixed conditions. Let me explain each one of them in detail. We are going to start with suspensive conditions. This is a condition that suspends the operation or effect of one or more obligation under a contract until the condition is fulfilled or until the happening or non-happening of a future uncertain event. For example, in hire purchase contracts, the passing of ownership is conditional on the payment of the last installment. So ownership will be passed to the buyer at the time he pays his last installment. Otherwise, ownership of the property will still remain in the seller's name. I have a case for you. In this case, Jacob sold and delivered a horse and a cat to Peterson for $8 to be paid in installments for 16 weeks. The agreement was subject to the suspensive condition that ownership of the horse and the cat was not to pass on delivery, but only after the purchase price had been paid in full. Peterson paid the first installment, but the horse died thereafter. So, it was held by the court that the risk remained with Jacobs, who was the seller, and he could not succeed in an action for the balance of the purchase price. The sale was suspensive and ownership did not pass to Peterson until the last installment was paid to Jacobs. So Peterson stopped to pay those installments for that horse which had died. Next, we have resolutive conditions. This is a condition in a contract which states that an agreement to the contract or some part of it will be terminated on the fulfillment of a condition. It leaves the contract operating, but as soon as the condition is fulfilled, then the contract ends and the parties have to be restored to their original position. For example, it is a common condition in a contract of sale that failure to pay an installment will allow the seller to cancel the contract. That is lex commissoria. Do you still remember? Then we have casual condition. It depends upon a future event which is uncertain to happen because of chance or because of a certain decision of a third person which is required. For instance, if I include my neighbor or my husband in the payment of the purchase price, that is a casual condition. Then we have the potestative condition. It depends upon a future event, the happening of which is within the power of the party in whose favor the obligation was framed. Fulfillment of contract is entirely in the control of one of the parties to the contract. So this one is like take it or leave it. Just take it or leave it. Is something like that. That is a potestative condition. One is in control of the contract, and fulfillment of the contract is dependent on that party who has the power to make the contract go on. Then we have mixed condition. It is a combination of two, that is maybe potestative and casual, or any one of all those we have just talked about. Now we have also exemption clauses. An exemption clause is a contractual term that forms part of a contract which attempts to either limit or exclude a party's liability to the other. This occurs when one party attempts to cut down the scope of their contractual duties or regulate the other party's right to remedies for a possible breach of contract. An exemption clause in a contract therefore seeks to exempt one of the parties from liability or seeks to limit liability to a specific sum in certain event. We have types of exemption clauses. The first one is limitation clause. This is where a party is limited from liability. And then we have exclusion clause. This is where a party is totally excluded from liability. So these clauses, they apply especially if a document is not signed. For instance, we are talking about tickets, we are talking about notices and programs. Then it also applies if the party knows about the clause, and also if reasonable steps are taken to bring the clause to his notice before the contract is made. I guess you are wondering where these clauses are found. The clauses are commonly found in parcel counters, dry cleaners, horse races, when parking a car in the parkade, or when leaving a car at a garage for repairs. So there will be a notice maybe saying that, maybe it's a parcel counter. It will be saying that goods should not be left for more than 2 hours, otherwise one has to pay. and it may be saying that you should not put very fragile goods like glasses, and also they refuse money in parcel counters. So they say we don't give back if anything is broken. So those are the clauses we are talking about. They exempt the other party from the liability of paying back everyone. Next, we have unsigned documents. These are documents we meet daily and are not signed. We are going to look at the legal implications of these documents. For example, we have tickets, receipts, programs, and notices. Remember, we are saying these also have exemption clauses, so we want to look at them in detail. First of all, we are going to talk about receipts. A receipt is a prima facie evidence of payment. A receipt is not a contractual document. The person taking a receipt does not bind himself to any terms or clauses printed on the receipt. When making a payment, the debtor should always demand a receipt, for if he is subsequently sued on the debt and he alleges that he has paid it, the proof that he has paid that debt is on the receipt. So the receipt is only a proof of payment. He should be given and keep the receipt as a proof of payment. It's not a contractual document. Then next we have notices. The general rule is that notices have got terms that are binding if the receiver was aware of the notice or the offerer had alerted the offeree as regards to the terms on that notice. So similar principles apply when reliance is placed on a provision of a contract which is posted up in a prominent position, such as the notice which says cars are garaged at owner's risk. Next we have tickets. Terms contained in a ticket are binding on the acceptor of the tickets, but it depends on whether the offeree was aware or ought to have been aware at the time of acceptance of that ticket that the offer was subject to particular terms. So usually you find on tickets that they write a clause saying that you should keep your goods. If they are lost, we do not pay them back. So any terms written on a ticket, they are binding. Next, we have signed documents. In general, the effect of signing a contract is that the party signing that contract is bound. This rule is applied not only when the person signing studies the document, but also when signing carelessly or recklessly, and when he fails to study the contract before signing. So, we are saying that the general rule is if one signs a document, he is bound to abide by all the obligations on that contract. He should perform his duty because he has just signed. So these are governed by caveat subscripto rule and also the quasi-mutual rule. Those are the principles which govern signed documents. Firstly, we are going to look at caveat subscripto rule. This rule means that let the signer be aware. The general rule is that a party to a contract is bound by his signature, whether or not he has read or understood the contract. He should ask if he is not understanding any terms of that contract before signing. So the general rule states, if one signs a contract, he is bound by his signature. For example, in this case, George, a hotel guest, signed a hotel register which contained contractual terms, some of which he completed by filling in blank spaces. The register had clauses written in Afrikaans and English stating that the hotel will not be liable for loss to guest property. George signed the register without reading some of the clauses. After a month, the goods were stolen and he sued the hotel. The hotel denied liability on the basis of the clause in the register. It was held that the hotel was not liable because by signing the register, George had become bound by whatever words contained in the clauses on that contract. George was bound by the terms since he knew he was signing a contractual document. Now, there are exceptions to this rule. We have misrepresentation, fraud, duress, undue influence, or if the contract is impaired by illegality or mistake. Then, next, we have quasi-mutual assent. This principle detects that if a party to a contract acts in such a manner as to lead the other party to reasonably believe that he was accepting the terms of a contract, that party shall be bound as if he had expressly assented thereto. The doctrine is meant to aid in resolving disputes on the existence of an agreement. This doctrine was adopted in Zimbabwe in the case of Diamond versus Kernick. That was in 1947. So, this principle, it highlights that if anyone does something or makes the other party in some way to think that he is accepting certain terms of a contract, that person is also bound by the terms he has made another person to believe he is accepting. So this is meant to resolve disputes in the courts. Now, lastly, let us look at the questions that are frequently asked. Firstly, explain the following terms: suspensive condition, resolutive condition, express terms. Give examples and clearly distinguish between express and implied terms. If someone signs a contract, is he or she bound by it in law? Discuss. Explain what the caveat subscripto rule says. Give the exceptions available to this rule. Those are the questions I had for you. Thank you so much, guys, for watching.